welcome to another VWV Higher Education webinar, this time brought to you by members of the Student Matters team. My name's Chris Roberts and I'm joined today by my colleagues Bradley Evans and Liz Smiley. And we're going to cover a topic that's preoccupied the sector for quite a while, to a greater or lesser degree, but has come back into focus recently: consumer law compliance and the student contract. Why are we looking at this again now? Well, rising student fees and concerns about the extent to which universities comply with consumer law mean that regulatory interest and scrutiny in this area remains very strong. And in addition to that, we have recent legislative change, an increasing number of service-related complaints, and significant ongoing litigation that could have sector-wide implications. So what are we going to cover over the next 40 to 45 minutes or so? Well, I'm going to start by considering the university-student relationship and what we actually mean by the student contract, before taking a high-level look at the development of regulation and enforcement in this area. And I'm also going to touch upon the OFS's new 5-year strategy, some recent consultations, and what these tell us about what we should expect from the regulator as it resets its priorities. Liz will then look at the consumer law regime and the implications of the new Digital Markets Competition and Consumers Act 2024, before Brad provides us with an overview of recent OIA case summaries of complaints with specific service issue elements, together with a reminder of where we've got to with that group litigation breach of contract claim. And then to finish, I'll take us back to the possibility of a model or standardised student contract and how that might work in practice should it get off the ground. And we'd be particularly interested to hear your views on that possibility at the end as well. So in terms of our context, the relationship between higher education providers and their students straddles public and private law. It can broadly be divided into 3 sources, creating a range of legal and regulatory obligations. Statute, by virtue of what's imposed by primary and secondary legislation covering issues such as consumer and equality law. A duty of care, by virtue of what's assumed through the relationship between the parties, albeit that the scope of that duty is clearly disputed and remains unclear. And contract, by virtue of what's agreed between the parties in exchange for fees. And it's been clear that the student-university relationship is substantially contractual since the decision in Clark and the University of Humberside back in 2000. But what's actually contained in the contract? It's clearly not just the terms and conditions that we spend most of our time talking about. We also need to consider ancillary materials such as letters of offer, regulations and core policies and procedures, which will all have to some extent contractual effect. And as the contract is subject to consumer law, we also need to think about pre-contractual information about important issues such as costs and variations and any representations that are made, as well as protections such as cancellation rights and cooling off periods to ensure that the arrangement's actually enforceable. So the contract's not a single document, and it's shaped by legal requirements that arise from students being consumers. And that's in part why a comprehensive student contract review is such a significant undertaking for providers. And it's why when we're instructed to conduct such reviews, we will make use of detailed checklists as part of that audit process to ensure that all of the required elements are present. We also need to think about regulation in this field. And as you'll be aware, there are lots of regulators that have entered the sector over the last 20 years or so to help protect student interests. The OIA, as the Ombudsman for Higher Education, established back in 2004, provides an independent complaint scheme that still forms a core element of the consumer protection regime. We've got the Competition and Markets Authority, just over a decade old now, with a general consumer law remit amongst other responsibilities. And of course, in England, we've got the OFS, created in 2018 to replace HEFCE and to take a more comprehensive and student-centric approach to regulation. Of course, we've got a new regulator in Wales now too. And all of these organisations continue to be involved in the consumer regime in slightly different capacities. And due to the way the sector's developed and they've come in at different points, it can sometimes be unclear which regulator is doing what, particularly with the CMA and the OFS. So I thought it would be useful to just briefly unpack how we've reached the current position. We go on to the next slide, please. So back in 2013, the OFT, which was actually first created in the 1970s, launched a call for information to the higher education sector. And after publishing its preliminary findings, announced that it wanted to undertake further work to assess the extent to which the practices identified may affect students and to clarify the responsibilities of universities under consumer protection law. And those initial findings were published in March 2014 and flagged concerns about certain non-compliant practices, but also about a general lack of regulation in this area. And the OFT recommended that further work would need to be done to try and inform and introduce a better regulatory regime. Later that year, the OFT was, of course, replaced by the new CMA, which immediately picked up the project. And in November 2014, it launched its own consultation ahead of the production of new consumer law advice. This was published in March 2015, clarifying consumer law obligations to undergraduate students, and that was at both publicly and privately funded universities and colleges. And only a few months later, they launched a compliance review to assess the extent to which universities were actually meeting those requirements. So it was a full review of the sector. And the resulting report in July 2016 revealed significant failings and included details of undertakings that the CMA had obtained from a number of providers to secure compliance and improve the way in which they dealt with their students. And we can look at some of those undertakings on the next slide, which shows that fundamentally, the CMA was looking to ensure that students got what they were actually promised when they signed up for a course. And we can see from this list that the universities that were pulled up were varied, mixture of public and private institutions, some new universities, some Russell Group universities covering England and Scotland. But the common themes of non-compliant practices included the inappropriate treatment of non-fee debt, so applying academic sanctions to unpaid fines, for example, which are seen as both inappropriate and disproportionate, creating barriers to the making or escalation of complaints, and applying variation clauses for important issues such as fees and course content in a manner that was deemed unfair. So it was apparent fairly early on that the same sorts of transgressions were appearing at different institutions of different types across the sector. And that's why the guidance the CMA produced was and still is so helpful and important. And if we briefly look back at what they've published, we had in March 2015 that substantive first set of advice, a 67-page document supplemented by a very brief summary signalling that the CMA was trying hard to make these points accessible both to institutions and their students. And the key issues that were identified included ensuring that material information is provided to students so that they can make properly informed decisions, maintaining clarity and transparency so that students actually understand the arrangement that they're making, maintaining fairness and striking an appropriate balance between the parties' obligations, ensuring that important terms are prominent enough and brought to students' attention, and of course ensuring that complaints handling is not only clear but accessible to the students who may need to use it. The advice was updated fairly recently in May 2023. It retained the same three key areas of focus, which was information provision, terms and conditions, and complaints procedures. There's some commentary on the practices that were adopted by providers during the pandemic, and there were some additional obligations were worked through to reflect the fact that the Consumer Rights Act actually post-dated the first set of advice by a few months. So looking next at the Office for Students, now the primary regulator for HE in England, with a wider role than its predecessor HEFCE, which was essentially just a funding body. And since its creation in 2018, the OFS has taken a lead role in the promotion of consumer protection for students, despite having no enforcement powers of its own. But it can act to address breaches of its regulatory framework. And it's done this by including in the core conditions of registration the C conditions around consumer law compliance. Originally just C1, C2, C3, which covered a requirement to have due regard to the CMA guidance I've already mentioned when implementing contracts, to cooperate with the OIA, and the scheme that it operates, and making students aware of their rights to access that scheme, and developing and publishing a student protection plan so that students can either complete their studies or be compensated if that's not possible. In 2021, a new C4 was added, which was, I think, a response to the pandemic, and this was to enable the OFS to intervene in the event of a possible market exit by a provider. And in 2022, the OFS entered into a partnership with National Trading Standards, a relationship that was actually first established a few years before, but was formalised and strengthened in 2022. And what this means is that the OFS can effectively direct enforcement action by working through the NTS. And the focus of that partnership remains compliant terms and conditions, checking whether there are any wrongful claims of OFS registration or degree awarding powers, and cracking down on misleading advertising, particularly by SA mills. The OFS has also published some guidance, the focus of which provides some insight into the issues that they as a regulator consider important. So we can see on the next slide two examples. From November 2022, they issued guidance relating to the disruption caused by industrial action, and noted the importance of providers having adequate communication and contingency plans, and to pay compensation to students when that was warranted. And in June 2023, as part of their Insight report series, they published a more comprehensive guide to consumer law and compliance. So it's more of a standalone resource, and that again sort of reiterated the importance of their partnership with National Trading Standards. And actually very recently, last month, they've published a further briefing on marking and assessment boycotts and what's expected of providers dealing with those sorts of situations. In terms of the intervention that the OFS and NTS has brought to the sector within the last few years, these have been published as consumer rights case studies, and the nature of these institutions that we've listed here reflect the greater level of diversity in the registered higher education sector now. So we've got, some of the very largest UK universities by student number, alongside very small specialist providers, but the actual issues have not really changed enormously from those that the CMA was flagging. So in addition to long-term problems such as unenforceable variation clauses, there's also been inappropriate use of entire agreement and limited liability clauses, ongoing issues with force majeure provisions, which were, of course, something brought into focus sharply by the pandemic and the disruption that caused. And perhaps most surprisingly of all, ongoing concern about the use of plain and intelligible language, which you think we would have all mastered by now. The most recent of the listed cases, the London School of Science and Technology, is interesting because not only did it cover a wide range of issues, but it showed that the provider might have to engage with the regulator more than once as part of this process to satisfy it that an appropriate outcome has been secured. And the noteworthy issues in that particular case study include making reference to extra costs that were not made clear, intelligible, and ambiguous to the students who might need to pay them, using an entire agreement clause that purported to supersede any written or verbal promises or representations, which we know is not now permitted under the Consumer Rights Act, referring to separate policies that are not easily located by the students, so they're not quite sure what's contained within them, charging late fees or high interest rates, which were considered far too high to be enforceable, and attempting to limit institutional liability just to the total course fee paid by students, or in other words, failing to acknowledge the possible right they have to compensation in addition to refunds if particular contractual obligations are not met. Going to look now briefly at the Office for Students' 5-year strategy. And it's in part a response to the persistence of the issues that I've mentioned, as well as criticism of the regulator itself, that the OFS has started to reconsider its priorities and formulate what it's going to look at, certainly over the next 5 years or so. They've identified 3 core priority areas, together with various ways of tackling them. So briefly, those are quality, about ensuring that education is provided, which has a significant and enduring impact on the lives and careers of students, which would involve the creation of a quality risk register, and also broaden the definition of quality so that it includes new issues of interest and relevance, such as transnational provision and freedom of speech. There's the wider student interest, which is about ensuring students do get what they were promised and actually benefit from a rewarding higher education environment. And that's where the potential model student contract project sits. And then there's sector resilience, ensuring there's financial sustainability in the context of constrained finances and effective governance so that we maintain student and taxpayer confidence. So if we look at that wider student interest limb and the specifics of what the OFS intends to do, we can see that there are a number of strands. They want to explore the possibility of securing the formal enforcement powers that they currently lack so that they can take a more direct approach to the problems that are identified. They still intend to publish case reports to disseminate best practice across the sector and to work with those other organisations, National Trading Standards, the CMA and the OIA, and to share intelligence, which of course I'm sure they are already doing. And when they do develop this model contract, if that proceeds, the plan is that they will work closely with the sector so that they do properly understand the best way of enhancing and protecting consumer rights. So I think they do intend to make it a collaborative process, although we don't know quite how that might play out in practice. We've also had recent consultations around changing, modernising the C conditions, which have long been seen as inadequate. So the original 3 C conditions I've already worked through, plus that additional C4 added in 2021. The main proposal now is that C1 and C3 will be replaced by a new condition, C5, in order to provide stronger student protection. Basically because, as we've seen, the existing approach is not having the effect that the regulator wants. And in particular, the OFS hopes that this will address misleading omissions of material information, contractual terms that limit provider obligations, complaints processes that are not effective because they contain unreasonable barriers, and also false or misleading claims on websites. So essentially, I think the OFS wants to change the way it looks at providers' student-facing materials and takes a slightly more interventionist approach if what they find isn't up to standard. Okay, so that's the context done. I'm now going to hand over to Liz so that she can take us through the updated consumer law regime.
Thank you, Chris, and good morning all. Over the next 10 minutes or so, I'm going to race through the recent changes to the UK's consumer law regime. I've kept my slides focused on the changes relevant to HE providers. We don't really have time in this webinar to cover the unchanged parts of consumer law, but do let us know if this would be of interest. So as of the 6th of April this year, the UK's consumer law has changed, and that's because the Digital Markets Competition and Consumers Act 2024 has come into force. So the DMCC Act covers a lot of ground and isn't always the clearest. In large part, it was drafted to regulate digital markets, so providers like Google, Alphabet, Amazon, and so on. The headline is that consumer law has changed, but the key areas remain the same, which Chris has already mentioned: information provision, terms and conditions, and complaints provision. So HE providers must still ensure that students are given upfront, clear, timely, and accurate information. But the DMCC Act does change the UK's consumer law regime, and that matters to HE providers because students are consumers in law. So as well as being a primary law that all HE providers need to comply with, for those that are registered with the OFS, it's also a condition of registration that they must comply with consumer law, which now includes the DMCC Act. This slide is a recap of all the acts that make up the UK consumer regime. So for commercial practices, after the 6th of April this year, we have the DMCC Act, which has replaced the 2008 Consumer Protection from Unfair Trading Regulations. the Consumer Rights Act, and the Consumer Contracts Regulations. On the next slide, I show how an HE provider might be held accountable to and by consumers. We have the OIA, which Brad will be speaking about, and is for individual student complaints. Then, as Chris has explained, we have the regulators, the OFS and the CMA. I'll be speaking about the CMA's new powers on the next slide, but for now, it's worth mentioning that we expect the OFS to remain the primary regulator for HE providers, but it will be informed and assisted by the CMA. If there's could we just go back for one moment? If there's a sector-wide or systemic issue, the CMA would likely have more involvement. We're expecting more guidance on how the two regulators will interact, so kind of watch this space. In the interest of time, I'm not going to go over the whole slide, and Chris has already spoken about the interplay between the OFS and national trading standards. But if you have any questions, you're welcome to ask them at the end of the webinar or contact us afterwards. On the next slide, I've just shown the headline of the changes that have been brought in by the DMCC Act and that are relevant to HE providers. The Act, if you've had the pleasure of reading it or, looking into it, is extensive and could be the topic of a webinar itself. So I've kept my slides focused on the changes that are most relevant to higher education, if nothing else, because it's not the easiest area of law to digest. So I haven't covered the unchanged parts of consumer law. The DMCC Act both replaces and updates the law around unfair commercial practices, and it introduces a new offence. The Act also gives the CMA stronger enforcement powers to remedy breaches of consumer law. On the next slide, I've just highlighted the key changes, and so the CMA can now enforce against any breach of consumer law, whether that's the Consumer Rights Act, the DMCC Act, or the Consumer Contracts Regulations, which you'll remember are the three main laws that make up the UK consumer regime. As of the 6th of April, the CMA now has direct enforcement powers in relation to consumer law breaches, meaning that it can conclude that a breach of consumer law has occurred and issue penalties accordingly without having to go through a court, which wasn't the case previously. It can also issue fines, which is new and was one of the criticisms of the old regime. And the fines are or can be hefty at a maximum of up to 10% of global turnover. But it's important to remember that the CMA is only likely to get involved in the most serious or systemic breaches, and even then it has expressed a preference for warnings and advisory letters in the first instance. So the standard route for most consumer law breaches for OFS registered providers will still be via the OFS. Moving on to the updated unfair commercial practices regime. This slide shows the changes that the DMCC Act has made to the existing law. The old regime is shown greyed out at the bottom of the slide, and the new regime is in colour at the top. The new Act, the DMCC Act, has the same core objective of protecting consumers from unfair commercial practices and is largely the same, but with a few key amendments. Firstly, there are now 32 banned practices rather than 31. The new banned practice is submitting or commissioning fake reviews, which I'll come on to later. Secondly, omitting material information from an invitation to purchase is now akin to a banned practice in that it's inherently unfair and there's no requirement to show that an omission has changed a student's mind. So essentially, a complaint can be made about consumer law a complaint can be made about these two areas of consumer law without having to show any impact. I've shown in the striped box, this is called the transactional decision test, and essentially for the offences that are attached to this striped box, you have to show that the commercial practice changed a student's mind in order to show that it's unfair, but you can see that for the 32 banned commercial practices and the omission of material information, you don't have to show that. So before I move on to a more detailed look at those two offences, just want to say now that higher education providers are also responsible for the actions of their representatives. In the Act, this is worded as people acting for the purpose relating to the trader's business and for persons acting in their name or on their behalf. And in English, that means that higher education providers will be responsible for the commercial practices, whether that's actions or omissions or something else, of their agents, subcontractors, marketing firms, and recruitment partners. That's quite key, so do keep that in mind over the next few slides. Tamar, if we could skip through to the quote. Thank you. So back to the offence of omitting material information. The Act defines material information as any information that the average consumer needs to take an informed transactional decision. So the first thing to point out is that that's a broad definition. It's wider than just the decision about whether to enrol. It includes anything that a higher education provider could do that could affect students in some way before, during, and after the decision to enrol. So that might include their decision or the student's decision to attend an open day, for example. The second thing to point out is that we do have some direction from the CMA on the topic. Chris has already mentioned the CMA's May 2023 guidance, and the guidance states that material information includes things like accommodation options, core modules, likely optional modules, contact hours, assessment methods, current and future tuition fees and other costs, and so on. It's a pretty long list. So any omission of this information that the CMA considers material is a breach of consumer law, whether or not it changes a student's mind, and therefore a breach of the OFS registration requirements. And it doesn't have to be you that submitted the information for you to be liable for the breach. It can also be your agents, subcontractors, marketing firms, and recruitment partners. On to the next slide, which is just flagging that we're now moving on to the second new offence, which is the addition of an extra banned practice, which is the submitting or commissioning of fake reviews. So again, it doesn't have to just be the HE provider, it could be agents, subcontractors, marketing firms, and recruitment partners. The next slide shows the definition of fake reviews, which is a review of a product, a trader, or any other matter relevant to a transactional decision that purports to be but is not based on a person's genuine experience. It's a pretty wide offence, and on the next slide, I've given some examples of what that includes. And that's not just submitting and commissioning fake reviews, but it's also not taking reasonable steps to prevent or remove fake reviews. It also includes publishing reviews in a misleading way, and that might be failing to publish negative reviews or giving more prominence to positive reviews, or failing to mention that a reviewer has been commissioned in any way, not necessarily just financially. So, like the omission of material information, commissioning or submitting a fake review will be a breach of consumer law, whether or not it impacts a student's decision. Finally, on the next slide, I've got the expanded definition of vulnerable, which is in the DMCC Act. Now, this is quite a minor change, because now vulnerability doesn't just include people who might be vulnerable because of their age, physical or mental health, literacy or credulity, as it was under the old law, but it also includes people that might be vulnerable because of their circumstances. You can see it's in green on the slide. So the explanatory notes to the DMCC Act gives us an example of context-dependent vulnerability, and they've included people going through mourning or through, people in mourning or going through a divorce or losing a job. And you can see how it's not a huge stretch to imagine that a young adult entering higher education or a prospective foreign student might be considered vulnerable despite not fitting into one of the old categories. So they might be healthy and literate, but still vulnerable because they're facing emotional stress, financial uncertainty, or unfamiliarity with the system. And this matters because consumer law often refers to the average consumer, which is someone who's generally well informed and circumspect. So if the average member of a target audience is likely to be vulnerable in a particular context, the CMA can effectively apply the standards of a vulnerable consumer instead. I'll give an example in a moment. But you might remember that the definition of material information includes reference to the average consumer. It says that material information is any information that the average consumer needs to take an informed transactional decision. So if students as an average group are considered vulnerable, the threshold for what is material might be lower and the duty to disclose might actually be more extensive than you'd think. For example, if we look at accommodation provision, where students are moving away from home for the first time, they might actually be placing a lot more weight on information about accommodation. So things like the safety, the support on site, or the proximity to campus. And you might find that you have a greater duty to disclose information about that than you would generally think. So, final slide is the key takeaways. And as I said, consumer law has changed, but the key message remains the same as it was before the DMCC Act. And I thought it would be helpful to illustrate this by actually summarising with a quote from the 2023 guidance, which still is, that is the kind of the crux of it. So higher education providers must still ensure that students are given upfront, clear, timely, accurate, and comprehensive information. Thank you, and over to Brad.
Thanks very much, Liz. Morning all, thanks for joining us this morning. So, as Chris mentioned a little bit earlier, I'll briefly be looking at some of the recent OIA case summaries and litigation regarding consumer rights issues. Next slide, please. Excuse me. Looking firstly at the OIA case summaries, all of you will be aware that the OIA is the primary route for students to address complaints, consumer rights related or otherwise, where they are unsatisfied with the university's response via the internal complaints procedure. Late last year, the OIA released a number of consumer rights related case summaries, and these really provide a helpful indication of the OIA's approach to consumer rights issues, trends and themes. When we were putting together this webinar, we had a little think about how best to address these, and we come up with an idea to look at these by complaint outcome. So firstly, looking at complaints and concerns that were either justified or settled. The first key case referenced some CMA guidance and specifically noted that material information upon which students rely to make an informed decision must be accurate and not misleading. In this particular summary, the settled complaint related to the accreditation of a course by a professional body, with the student stating that the pre-enrollment literature suggested accreditation would be given. Upon the OIA review of the case, there was information available to demonstrate that accreditation information was provided to students. Secondly, moving on to the importance of time and acting promptly. One particular example looked at a first-year undergraduate student who was withdrawn from their studies after failing a resit examination attempt in a core module. The provider offered what, in the OIA's eyes, would have been considered a reasonable remedy had the matter been resolved more quickly. In this example, the provider was criticised for not considering alternative remedies when the student said they didn't want to return to their course. Moving on to complaints that were partially justified. Firstly, with a focus on industry access and career services. So these elements were factors that were considered as part of a complaint, and they were listed in marketing materials, However, it was not made clear that these were additional services and the provider were not obliged to deliver these. Upon the OIA's review, they found that industry access and career services are material factors for applicants who are choosing where to study, and inaccurate information about these opportunities could constitute a misleading omission under consumer protection law. Moving on to considering the impact of vulnerable students, and this one slightly links to the earlier example of time and acting promptly. In this specific example, a student had a diagnosis of autism and the provider was criticised for the delays in managing the complaints process. Again, whilst the proposed remedy was considered reasonable, it was found that this approach did not consider the impact on the student, and an additional distress and inconvenience payment was ordered. Finally, moving on to not justified complaints. So if we just go back one slide, please. Thank you. Moving on to not justified complaints. I'm sure most, if not all, people attending the webinar today have dealt with unrealistic expectations. And whilst fact specific, this summary looks into that in a little bit more detail. This summary looked at changes which were based to ambulance-based and hospital-based components of a course. There were some key points to note, including that some of the factors influencing the change are outside the provider's control, and there was evidence to suggest that these changes were in keeping with the normal aims of the programme and students were able to meet the intended learning outcome. In addition, these changes were approved by the profession's regulatory body, and the provider had offered alternative and additional training opportunities, including an externally accredited course. Having considered all of these factors, the OIA found that the provider acted reasonably and properly in the circumstances. Finally, we're looking at obvious mistakes. In one specific example, the OIA demonstrated that there was a mistake on an offer letter where there was 0 fees chargeable. The OIA found that the solution offered by the provider following the complaint regarding the mistake on the offer letter was reasonable in the circumstances. This solution was a 20% fee waiver and an opportunity to withdraw with no fee liability as a result of the unintentional mistake on the offer letter. I appreciate that's a very whistle-stop high-level summary of the more recent OIA case summaries, but I really hope that this provided you with a useful indication of the wider OIA approach to consumer law-related complaints. Next slide, please. So when I look back at this morning, my original thought was this title slide may be slightly misleading because it may suggest that this is one student case, but many of you will be aware that this litigation involves many students, and it's really a watershed moment for both HE and wider consumer law obligations. So a very, very brief background. This case has been ongoing for a long time, with the particulars of claims sent in February 2023. The claims relate to both industrial action and the impact of university changes during the COVID-19 pandemic, specifically alleged breaches of contract in failing to provide campus-based tuition and access to facilities. The litigation is seeking performance-based damages, that being the difference between the market value of the services promised and the services actually provided, and damages for distress and disappointment. The students' representatives sought a group litigation order, or GLO, and this was first considered in May 2023. In very basic terms, GLOs can be used to manage multiple claims which have common or related issues of fact or law. They seem to be more efficient to manage large numbers of similar claims and allow for wider access to justice. At the time of the application, the judge stayed proceedings for 8 months to allow settlement discussions to take place. These were unsuccessful, and the GLO was reconsidered in June 2024. Next slide, please. Excuse me. So what were the parties' arguments? These are summarised on the slides, and without wanting to give any spoilers, I will focus on the university's arguments. In very simple terms, the university position was that a JLO wasn't required for these cases. The arguments focused on the individual nature of each claim, and importantly, the specific impact on that individual. The arguments also looked at the time that passed for students to bring claims and a wider concern regarding avoiding further unnecessary costs. Next slide, please. Senior Master Cook agreed with the university and did not order a GLO. There's a quote from the judgment on the slide now. I'll quickly read that. It would not be appropriate to make a GLO in this case, and that the litigation will be best resolved by the creative use of the court's existing case management powers. It was Senior Master Cook's view that a GLO would create unnecessary delay, increased costs, and was simply not needed to manage the case. Next slide, please. So what's next? So 10 test cases are scheduled to be heard in early 2026, and these really will dictate the wider approach to the management of these claims moving forward. If successful, this will pave the way for numerous legal claims against universities for disruptions to students' learning as a result of either the COVID-19 pandemic or recent strike action. 1KG reported a potential bill of between 600 million and £1 billion if successful claims are brought by all affected students. Focusing on the key points today, I suppose the key message is not to panic. In the 2024 GLO decision, the court ordered a stay on all future claims arising from the same facts and issues that are not already a part of this litigation, pending the outcome of the test cases. Interestingly, the students have also been ordered to provide further information regarding the specific impact of disruption and their claim more generally. This may mean that some cases are unsuccessful and should assist in avoiding the pursuit of unsubstantiated claims. Finally, and I accept this is probably a boring legal perspective, this litigation should provide welcome guidance on the court's interpretation of force majeure clauses in student contracts. Back to you, Chris.
Very much. Thanks, Brad. And yeah, I think it's difficult to overstate the significance of this particular piece of litigation. And we've just got 10 test cases. And I think the idea is that obviously, depending on how those go, the multitude of other cases will either be dropped entirely, or they'll be settled, or they'll be disposed of by way of mediation. And it's interesting that the claimant lawyers were pushing, I think, for a global settlement of a sort of nominal sum per student. But when you extrapolate the cost of doing that, you can see why university, pushed back and said, no, you've got to break down these claims in a granular way. We've got to understand the issues, not only to dispose of these particular cases, but to inform how we do things in the future. And clearly the outcome, I mean, what we see happening next year is going to have a significant impact and be highly relevant to a new model contract if one is now developed. So just for the last few minutes, I'm just going to return to that topic and to the next slide, please, the OFS strategy and what it is they're proposing to do. So although there's no ambiguity around the OFS's commitment to ensuring that students receive what they were actually promised, and we know that there are plans to gather and analyse data and insights from students, institutions and others around what's expected. What's far less clear is how a model contract or contracts would actually be developed to address these points. So we've got no detail around how this will be done, how long it will take. And whilst that is ongoing, we have to expect that the OFS will just continue to work with the NTS, with the OIA and the CLA to maintain the system as it stands, perhaps with some changes to the C conditions. But it will probably be business as usual for a little while yet. On the next slide, I've just tried to capture the fact that having a new standard model contract in HE is not a new idea. This is far from the first time it's been raised as a possibility. And we can certainly trace arguments in favour of a student contract back to the early 1990s when Dennis Farrington wrote an article arguing very strongly that both universities and students would benefit from their obligations being much more clearly defined. And these arguments were repeated, reinforced in years subsequent by Farrington and Palfreyman in successive editions of their well-known HE text, but they didn't really ever gain much traction despite even providing a template contract for the sector to consider. That was until around 2017 when as Minister for Universities and Science, Joe Johnson recommended that student contracts were considered so that there was better clarity about what students would gain from their education and better opportunities for them to seek redress if that was not delivered. And in 2019, as Education Secretary Gavin Williamson formally called on the chair of the OFS to review the effectiveness of current practices and consider the options for standard contractual templates. So there was hope that that this initiative would take off at that stage. Of course, COVID intervened and deflected the OFS's resources for a couple of years. And it was not until the disruption of the pandemic subsided that they could return to the issue. There were some other commentators in the sector. There's an interesting HEPI article from 2021 that identified the possibility of student contracts becoming part of a different regulatory approach, as if we implemented contracts across the sector, the OFS could focus its attention on those and the extent to which they were being followed, rather than taking the more piecemeal approach that we've been describing over the last 40 minutes or so. And that was also the message in the Bean report in 2024. So looking at how the regulator might reset its priorities, one of those recommendations was that they would enhance their enforcement powers so they could take a more direct approach as regulator. But another was that the model student contract project would be brought back and that an approach would be developed, ideally with proper consultation from those affected. And that is what the 5-year plan is now suggesting. We see on the final slide just a simple summary of what are fairly obvious advantages and disadvantages of adopting this standardised approach. I mean, on the plus side, it would, in theory, allow the recurring issues that we've heard about, clarity, transparency, etc., to be addressed. It should improve enforceability and reduce the number of disputes, so cutting the amount of time and resource that institutions and others have to spend on those issues. But on the downside, it is difficult to see how such a contract would be designed for use by a sector that's now more varied than it's ever been. Some have expressed concerns about institutional autonomy. I think that's an issue that's often raised whenever significant change is suggested, and it may or may not be a valid problem here. But on a more practical level, there are some obvious issues around who would design and maintain the contract and how any changes to it would be implemented. Although we can, of course, expect the OFS, the CMA, to have some significant input in how the contract looks and how intelligence about it is shared and pooled and reflected in the final version. And then very briefly, I've had a quick look at the sector organisations that have issued public responses to the consultation and identified their views on the model student contract in particular. We know that UUK is broadly supportive of this idea, but believe that a proportionate approach is needed because there are providers out there who already have what are considered to be good contracts, and they don't think they should be required to change those. Advanced HE also supportive, but only if it actually manages to do what it's intended to do, which is to clarify legal obligations, particularly in controversial areas such as industrial action staff strikes. Independent HE, on the other hand, are not supportive of a model contract, believing that such an approach wouldn't be capable of capturing the sector's diversity or the significant changes to education that are expected over the next few years. And Guild HE, similarly, support the strategy's aims, but are unsure that a model contract can be sufficiently future-proofed and considers it something that would require significant further sector consultation before we can really plan this in a meaningful way. Okay, so that brings us to the end of our slides. And we thought now that we might ask you whether you believe it's a good idea for the sector to adopt a model student contract, and then I suppose we can share our views as well. So if you'd like to vote. How's that? How is that going, Tamar? Aha. So thank you, everyone. So we've got, it's actually, well, close-ish, although it's clearly a yes. So that is interesting. And it would be useful to hear in the Q&A if you want to share your views on why you think it would be a good idea, because we do have a clear sort of win on that front. If I start, I mean, my view on this is that on balance, I can see why at this stage, after everything that's happened, a fundamentally different approach to this issue is needed. And clearly, what's been going on through a sort of soft touch regulation system hasn't made anywhere near the positive effect that was hoped for. I think it's also important to recognise that standard contracts have been implemented in other educational sectors. So I'm thinking in particular of the independent school sector, where there have been standardised contracts, standard terms and conditions for nearly 30 years. VWV developed one of the, or perhaps the original, what's called the parent contract, to standardise that relationship originally in order to improve fee recovery by schools, by having greater clarity on what the obligations of each of the parties was. And that contract template predated the consumer law regime as it stands now, but has continued to evolve as the law has changed. It's also survived scrutiny from the OFT back in the early 2000s, when there was concern about any contractual document that was adopted by so many institutions across the market that it actually could distort the behaviour of that market. So it was modified. It has continued to evolve. It now reflects the latest consumer law requirements in order that it's both fair and enforceable. So there are precedents for this. We don't want to conflate schools and universities. They're clearly very different types of organisation. But as HE has moved into a fee-paying consumer law-backed system, I can see that there is a sort of there's a confluence, I guess, of the issues that are affecting those sectors. They're much more similar now than they ever used to be, and it is possible to distill the educational relationship into a standardised form. Perhaps what's needed in HE is going to go beyond a single contract. I think that's probably unrealistic. I think most independent schools, you could just have a day school contract and a boarding school contract, and that pretty much covers what you need. I think within the now diversified HE sector, where you've got very large institutions, full faculty research institutions, as well as very, very small micro providers focusing on niche areas, you're going to need more than one type of contract to accommodate their particular characteristics. But again, that doesn't necessarily mean that it makes the project unworkable. I don't know if my fellow panelists have any other views to share, or indeed anyone in the audience. And if not, we can obviously move on to any questions.
There was one question, Chris. I don't know if I chose to see it, but perhaps would it be helpful if I read it, and then
yes, please.
If I can very kindly pass on to you to answer, if that's all right.
Sure.
So, regarding the Office for Students, the House of Lords, is the House of Lords inquiry in the report likely to influence any changes for the better for higher education providers? The House of Lords findings had many criticisms of the OFS approach in its first 5 years of being. Some of the problems may be down to the OFS itself. OFS.
Yeah, I mean, I think that is a good question, and I think the House of Lords inquiry is going to have a significant effect on everything the OFS now does. Thinking about what the criticisms were, I mean, there were clear concerns about the lack of meaningful engagement between the OFS and providers. There was concern about the OFS's approach being too prescriptive, too distant, draconian, lacking in transparency. So I think if it was to take an approach to this project that addressed all of those things, that's clearly got to be a good thing for providers. I think it emphasises that any model contract or any significant change to the approach to consumer law regulation will have to be through extensive consultation. It will have to reflect the views of providers, not just be imposed in a top-down way by the regulator. And I would imagine they will also want to have significant input from students, you know, as you would expect when we're dealing with consumer law issues. It's all about appropriately balancing the obligations and rights of the parties to that arrangement. So I suppose in short, I do think the House of Lords inquiry and the criticisms will have a positive effect. Okay, we've got another comment. So this is against the idea of model contract on the basis that if I just read it out, the NHS funding agreement all universities are forced to sign does not really work with no parties properly understanding it and being performative. A better approach would be the QAA benchmark approach that states a model contract should contain this content and this type of drafting is prohibited. This then allows institutions to tailor to their needs and provision whilst ensuring that there's a common framework that each university covers. Yeah, so I suspect that's an example where there's the flexibility issue. And I can see the argument that unless the parties properly understand what the contract means, then clearly it's not going to be a successful distillation of their relationship. Benchmark approach by the QAA, yes. Yeah, and this type of drafting is prohibited. Yeah, I mean, I suppose it is a question of balance. There won't be one contract that will work for every type of course. And I can even see, and if we think about just the sheer diversity across the sector, I mean, it's not even the case that every student accessing a HE course is a consumer. I think there is a correct assumption that most of them are, but obviously the CMA guidance and most of the publications that have come out are directed mainly at undergraduate provision. There will be institutions offering postgraduate professional courses for qualifications where actually the students are not technically consumers. So would we need such a contract in that situation? Arguably not. So there is going to be a lot of nuance in this. Although I am saying broadly in favour of this idea, which might be surprising as a lawyer, because you might think, well, it's going to deprive us of the opportunity to continue to review lots of different contracts on an indefinite basis. But thinking more pragmatically, I think it would be good for the sector if we could at least narrow down to a list of potential contractual templates to cover the key variations between types of HE provision, types of students, and hopefully that will provide a slightly better way to ensure that that rights and responsibilities are understood and enforced. Now, I think we've run out of time. I've got some questions here, and I'd be pleased to answer those by way of follow-up. So I think we've recorded this session. I think we will have access to the questions and we can answer them there. There's one question about deposits and another around material information. So we will get back to you on those as soon as we can. But thank you very much for attending today. I think there's a feedback box on screen now. So if you could fill that in, we'd be very, very grateful. But thank you.